Hey everybody, welcome to Counsel, a Hirschler video series focused on the legal and business trends keeping employers up at night. I'm Andy Sherrod and I'm joined virtually by my colleague Jaime Wisegarver. We're both members of the Hirschler employment law team. We thought we'd kick things off with a 5-part series of short discussions addressing some new but very important laws that were enacted in Virginia that it will affect almost all employers. The news has understandably been focused on COVID-19 lately, but the impact of these new laws really can't be understated. Chief among them is the Virginia Values Act. Jaime, you want to tell us a little bit about that one?
Absolutely. Andy, the new law significantly expands the Virginia Human Rights Act in a few different ways. First, it expands the list of protected classes. So everybody's already familiar with the fact that the VHRA prohibits discrimination on the basis of race, color, religion, national origin, gender, age, disability, and veteran status. Now also included in that list is sexual orientation and gender identity. Second, it expands the scope of the Virginia Human Rights Act so that it now covers all employers with more than 5 employees. That's a significant change. And third, it expands the remedies that are available to plaintiffs whose employers violate the Virginia Human Rights Act. So in addition to money damages, plaintiffs can also recover uncapped compensatory damages and attorney's fees. They can seek injunctive relief, and employers may face civil penalties. Andy, I know you've given some thought to the practical impact of this new law. What are your thoughts on that?
Yeah, I have. Well, obviously, first and foremost, employers need to update their anti-discrimination and harassment policies to make sure they include gender identity and sexual orientation. That's just a starting point. But I think that the real game changer here is the change and expansion in coverage under the VHA and also the expanded remedies under that statute. Previously, the VHA really only covered smaller employers that weren't covered by the federal anti-discrimination statutes like Title VII. But now the VHA will provide remedies for all sorts of discrimination claims that are comparable to or in sometimes better than what you can find under Title VII. So what I would envision starting in July is a real shift in employment discrimination litigation from the federal court, where it's historically been, to the state court. And that's a real game changer because in federal court, there's a mechanism called summary judgment that businesses can use to get rid of cases that don't have factual or legal merit. But in Virginia, it's darn near impossible to get summary judgment. So if a case isn't settled, it's likely going to go to a jury trial. So the practical ramification of that is that employers really need to look at their litigation budgets, make sure that they've got the resources to defend against discrimination claims, but I think even more importantly, focus on that compliance game. Make sure you're training your staff to avoid claims before they get started.
So employers need to be prepared to shift away from litigating employment disputes in federal court, and now it sounds like they're going to be a lot in state court where they're going to be more expensive to defend. Thanks, Andy. And to our listeners, thanks for listening. If you have any questions about this topic or if suggestions for other topics that you'd like for us to cover, please feel free to contact us. Stay well.